webinar, Dealing with the Media, presented by Catherine Flaherty, San Diego County Deputy District Attorney, will begin shortly. Today's presentation is made possible by a grant received from the Office of Justice Programs through the Bureau of Justice Assistance. APA is very appreciative of their financial assistance and commitment to improving the justice system. By the conclusion of the webinar, you will be emailed a short electronic survey to complete regarding this webinar. This survey helps us continue to provide quality training to you at no cost to your jurisdiction and assist in future planning for continuing legal education. In appreciation of your completion of the survey, all surveys will be submitted in a drawing for a free 1-year APA membership. During today's webinar, you will be able to submit questions for the speakers using the question box on your GoToWebinar toolbar located on the right side of your screen. These questions will be forwarded to the speakers, and we will try to cover the issue during the live presentation. If you need additional assistance, please feel free to contact us or the presenters directly following the presentation. We are very excited for today's webinar presented by Catherine Flaherty. Ms. Flaherty is the Deputy District Attorney and in-house Professionalism Ethics Advisor at the San Diego County District Attorney's Office. She earned her Bachelor of Arts degree in journalism from the University of Southern California and began her career as a news producer and reporter at various news stations in California and Utah. After many years as a reporter, she received her Juris Doctor degree from the University of San Diego Law School. In 1995, Ms. Flaherty joined the San Diego County District Attorney's Office as Deputy District Attorney. Assigned to the Family Protection Unit, her duties included management of a large criminal caseload from issuance through jury trial. To date, Ms. Flaherty has argued 104 jury trials to verdict. Thank you, and I will now turn the webinar over to Catherine Flaherty to begin today's Final Fridays webinar.
Thank you, Nikki. Let's see. Hold on just one moment. All right, here we are, Association of Prosecuting Attorneys. Thank you so much for asking me to do this Final Friday webinar, Dealing with the Media. And you already know that I am with the San Diego County District Attorney's Office. My name is Kate Flaherty, Catherine Flaherty in court, of course, but feel free to call me Kate. And my background is really twofold. I have been a deputy district attorney now. I'm in my 17th year, but I had a full other career before I went to law school. I graduated from USC in '81, feels like 1881, with a degree in journalism. I wanted to be a reporter along the lines of Woodward and Bernstein, but instead I was attracted by the lights of a TV newsroom, and I got hired at the ABC affiliate in Salt Lake City, where I worked for 2 years, just kind of learning the ropes. Then I went to the ABC affiliate in San Diego, where I ended up staying, and after almost 8 years in TV news in San Diego, I went to law school. I had covered enough criminal trials as a reporter and producer with KGTV that I became absolutely enamored with the work that prosecutors do, and I went to law school for the specific purpose of being a prosecutor, and I am so glad I did. It is a wonderful job and a wonderful life. So I worked as a deputy DA, a line deputy DA, for a number of years, and I was asked to begin to help other prosecutors in my office learn how to deal with the media. It was an honor to be able to do that, but the one thing that I was sort of surprised by was how much fear there was, how much fear and worry about talking to reporters there was by my colleagues. And way back in the beginning, you know, we're talking a long time ago, 15, 17 years ago, there were old school prosecutors in my office who wouldn't talk to reporters. They would dodge them. They would not return their calls. They'd race down the hallway to keep from having to actually be interviewed. And that changed. In our office, there was a complete sea change on that. Now we absolutely talk to the media about everything that we do, but that doesn't mean people aren't still worried. when I would talk to my colleagues, I would ask them, what is it that you're afraid of? And this was the answer that I kept getting. I mean, people thought that news reporters were out to trick them and make them say silly things or ignorant things, and that they would end up looking really bad. And I was reading this book recently on prosecutorial misconduct, and I saw this quote that was in the chapter on dealing with the media, and this actually said that experienced news reporters try to trick people, meaning prosecutors, into saying things they shouldn't say. And I looked at this case site. Okay, I wasn't a prosecutor in 1924, but I have to say, based on my 10 years in TV news before I went to law school, I don't think there is an epidemic of brilliant news reporters who are set on tricking prosecutors into saying things that they shouldn't say. You know, if you're the kind of person that gets, you know, really flustered easily, not many trial lawyers are, but you know, you could be confused by something, but I don't think that's a reporter's intent. You know, the vast majority of reporters are just trying to get the story, and they'll ask hard questions if they can, but you are absolutely able and capable of giving straight answers that will make you look solid and like you know what you're talking about. There really is not a reason to fear being approached by a news reporter. So what we're going to talk about today is the basic rules of governing prosecutors who are going to talk to reporters. There really is hard and fast rules about what you can and can't say. We're going to go through that, and then we're going to talk about how exactly you want to present yourself so that you do appear in the best light possible. There are a bunch of tricks to that which I am going to discuss. But I do want you to understand your primary concern when you are talking to reporters are twofold. You have to protect the rights of the defendant who is accused. You know, you cannot use your platform in the public eye to give yourself an unfair advantage in the minds of the public. So, you know, you really focus on what you shouldn't say that's going to compromise a defendant's right to a fair trial. However, you always are going to try to maintain a relationship with the media that will keep that flow of information going. The public has a very legitimate interest in the work that we do, and that's how the conduit of them being educated about the prosecutorial function is you, the prosecutor who has the case that they're interested in. So you're going to work with reporters, but within your guidelines, so you're always protecting the defendant's right to a fair trial. And the one thing I did want to say is I know that you were invited to ask questions. I want to just emphasize, please feel free to submit any questions that you have whenever you have them. I will take them in order as they're submitted. You know, use this. This is your hour. Use this if you want to pick my brain about any problem or issue that concerns you in this subject matter. So the rule that you are going to be always paying attention to is ABA Model Rule 3.6, and you see the introductory paragraph up there on your screen. Now, I haven't looked at the adopted rules in every particular state, but I've looked at a lot of them, and most states have adopted either this rule verbatim or they have adopted something that is so similar it might as well be verbatim. So this is going to apply to people in most every state that will be listening today. So go ahead and read this. Essentially, it says a lawyer. So if you're a lawyer, you're handling a case, some type of criminal matter, you are not to make an extrajudicial statement. What does that mean? Simply outside of court. That you know or reasonably should know will be disseminated by public communication excuse me, and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. So, you boil that down into plain language. You can't make a statement out of court that you either know or ought to know is going to be transmitted by a reporter, either on camera or in print, that is going to substantially prejudice a defendant. Okay, so what does that mean? I mean, you've got to get down to specifics to know exactly what that means. You may state the claim, offense, or defense involved, except when you can't. And that would involve matters like juveniles or any case where you cannot name or identify a defendant. You also have the information contained in a public record that you may state. You can talk about how an investigation is in progress, and you'll always be asked about scheduling or result of any step in litigation, and you can talk about a request for assistance in obtaining evidence and information that's necessary for the case. Now, I do want to emphasize that this rule applies to both prosecutors and defense attorneys. So when I say the claim, offense, or defense, I don't picture in my mind prosecutors talking about actual defenses. We talk about what the claim is, the charged offense, typically, but a defense attorney under this rule is allowed to talk about the defense. Now, information contained in a public record, I put a little asterisk by there because I think it's important to remember this rule permits you to discuss information contained in a public record. However, there may be information in the public record that is so prejudicial that it would be unwise to talk about it outside of court. And I will give you some examples of that as we go through. Now also, you are permitted to talk about a warning of danger concerning the behavior of a person involved if you have reason to believe there is harm to the public. So if you have a defendant on a case already issued, if you have a defendant that is not in custody and out or has made threats, and if you have a good faith belief that you have to warn the public, this rule allows you to do so without being penalized for prejudicing his right to a fair trial. Now, also in a criminal case, you can talk about the identity, residence, occupation, family status of the accused. I also see that as more of a defense function than a prosecutorial function, but that's fine. If the accused has not been apprehended, information necessary to aid in the apprehension, what their physical description is, where they were last seen, you can talk about something like that. You can talk about the fact, time, and place of arrest, and again, that's something that it sounds just so basic to us, but news reporters are always wanting to know when and where somebody was arrested. So do pay attention to that. The identity of the investigating and arresting agencies that are involved, you can also talk about that. And especially if you have the type of case where you want to give somebody some information or a soundbite, it's never a bad idea to offer the names of the investigating agencies and, you know, say that they're on it. It's good PR for you and the investigating agencies to mention them. So don't forget about them once the case has been submitted to your office. Never a bad idea to do that. Now, there is an interesting exception in this rule that I want to talk about, and it allows a lawyer to make a statement that a reasonable lawyer would believe is required or necessary to protect a client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Now, what that means to me is if you as prosecutors have a case and the defense attorney is one of these guys who really likes to talk publicly about the case, and they get out there in front of the cameras and really start in on unfair prosecution, or, you know, what is the DA's office thinking? If you and your supervisors conclude that there has been damage in the public mind to the prosecution of the case, this exception does allow you to make a public statement defending the issuance or the prosecution of a case. But this exception is also careful to say the statement should be limited to whatever is necessary to mitigate the recent adverse publicity. So just because you have all this information at your fingertips doesn't mean you can hit it out of the park. You know, you couldn't show a video of the defendant committing a crime, but you can make a statement that is going to help mitigate whatever the defense attorney has done. So, and along with this exception, it does remind in subsection B that no lawyer associated in a firm or government agency with the lawyer subject to paragraph A shall make a statement prohibited by paragraph A. And all that means is in a prosecution office, if the individual prosecutor handling the case is prohibited by this rule from giving the media certain information, so is everybody else in the office. No other lawyer, no other prosecutor can run this rule by giving that information directly to the media. So everybody in the prosecution office is held responsible for compliance with this rule. Now, would the media go around a prosecutor and ask another prosecutor about certain facts of the case? Sure, it's been known to happen, you know, depending on how high profile it is, how salacious it is, how much interest there is by the public. You know, journalists are always going to try to work, you know, various angles to get more details about a case, and, you know, if they can find a leak and get information that way, so they do try. You know, we go back to that original quote, do I consider that trickery and persuasion? I don't. You know, they're trying to do what they're trying to do. You know, we are always able to say, no, we can't talk about that, if that's the appropriate response. Believe me, they're used to being told no. It's not going to hurt their feelings at all to hear a no from you. The rule also talks about informing the public generally. And they say, look, the value of public commentary is great, and the likelihood of prejudice to a proceeding by the commentary of a lawyer who's not involved in the proceeding is small. So this rule is only going to apply to lawyers who are involved in the case and their associates. And so what this means is when there's a high-profile case, you are always going to have the media trying to get people to comment publicly who can. And that's, you know, when I see these big high-profile cases, I always think of them as the Retained Defense Attorney Employment Act, because these lawyers are always going on set at the local TV news stations and just, you know, giving their little spiel on whatever it is that they think about the case. The lawyers I know who do that aren't doing it for the money, even when they are hired to comment on a high publicity case that's going on for a month. Maybe they'll get paid something like $1,000 to be on call for a month. But of course they do it because it's free commercials for them. You know, they're hoping their face gets into the minds of the public, and the next time you get arrested, you hire them. It's harder to get prosecutors to talk, and what happens is the TV news stations go to former prosecutors who are now in private practice, because nobody who's currently associated with the prosecutor's office can comment, but former prosecutors can give the prosecution perspective, and there's nothing wrong with that. So that's just kind of an interesting little side note. We do have a question. A question from Janet says, if enforcement officers say something a prosecutor cannot, can it be imputed to the prosecutor? It can. I am actually going to talk about that. That is part of ABA Rule 3.8. So Janet, just stand by. I will get there in a few minutes because I want to talk about that specifically in more detail, and I promise you I will do that. But I want to get through the rest of 3.6. So what are the problem areas? If you can talk about the case, what specifically is risky as far as substantially prejudicing a defendant. If you talk about the character, credibility, reputation, or criminal record of a party, a suspect, or a witness, or the expected testimony of a party or witness. That's what it says in the rule. In a criminal proceeding that could result in incarceration, the possibility of a plea of guilty to the offense, or any confession, admission, or statement given by a defendant or suspect, or that person's refusal or failure to make a statement. So here we are. Let's go back to part one. Character, credibility, reputation, or criminal record. I don't think you're going to find many prosecutors talking about character of a defendant or witness publicly while the case is still moving through the system, or credibility or reputation, but we get asked all the time about the criminal record of a party. And this is a perfect example of what I said a few moments ago about information that is contained in a public record. Well, oftentimes criminal defendants have criminal records that are part of a public record. So does that mean automatically we can talk about their criminal records to reporters just because it's part of a public record? I think it's dangerous. It's inherently prejudicial to learn about somebody's criminal record. And for us to be talking about it outside of court, we are giving sort of the stamp of authority to this criminal record, which suggests if they did it before, have they, done it again? The important distinction here is that reporters, through their First Amendment rights, that's codified by statute in every state, slightly differently from state to state, but the reality is reporters have the right to these court files and computerized systems that list criminal records, and so they have their own ways to criminal records. They are going to include that in their stories, both their TV news stories and their print stories, but the important thing about that is that it doesn't come from you. So when they're asking you about details of a criminal record, you can always say something like, well, I believe you have your own access to that information that you're entitled to through the First Amendment. You're not answering, you're not giving that to them. If you said it in court, so it's part of a public record, and it was legitimately part, for instance, of a bail argument to the arraignment judge, and you talked about flight risk in terms of enhanced penalties and prior criminal records or danger to the public for that reason, you've made your pitch to the judge, but remember, that's not an extrajudicial statement. That was in court, and you are doing your job as an advocate to make the court aware of any danger to the community or flight risk. But once you step out of that courtroom and the statement would become extrajudicial, consider not answering the question. And you can say, you're well within your rights to say, anything I said about the defendant in court, I've already said, and I won't be repeating that statement outside. And they're absolutely free to use what they've already got in court, and you are completely protected. This rule doesn't apply to you at all. The danger, I think, is when you take something that you said in court and you think, hey, well, the horse is out of the barn, now I can say whatever I want out on the courthouse steps. Most defense attorneys will challenge your right to do that, and they will invoke this rule. And they may well complain about that type of thing, either to the court directly if they think their client's been prejudiced, or they may file a complaint about you with the state bar for violating that rule. So that's always something that you want to think about. Now, also, the possibility of a plea of guilty to the offense. You would be surprised how many times prosecutors get asked, well, this case seems like a slam dunk. Do you expect a guilty plea from the defendant? Because they already know so much about the case, how a high-profile case is unfolded based perhaps on what police officers have already told reporters, based on news conferences that a police chief has already held. So, you know, in the public mind or a reporter's mind, it may feel like something that should be pled out immediately, but of course they won't ask the police officer that, they'll ask you. So you're not ever going to say something like, absolutely, this thing is solid. If you know, he's an idiot if he doesn't plead guilty. You know, you're not going to ever say anything like that. A dignified response to that question is, we will be proceeding with a preparation and investigation of this case as though it's going to trial. You know, you are in trial mode. You are in forward motion. You're not going to talk about anything having to do with the plea. Also, you're going to be extremely careful if you are asked about any confession or admission by the defendant or their refusal to give a statement. You know, the way I think about it, if it would be error to talk about it in court, you're not going to talk about it outside of court either. And my personal opinion is that there is probably nothing more damning than a prosecutor speaking publicly about a confession of a defendant. That tends to seal guilt in the public's mind, and it is extremely prejudicial. And, you know, I can remember a colleague coming to me. She had a very interesting case. It was a child molestation case by a hospital worker. He was a respiratory therapist at Children's Hospital in San Diego, and he had targeted children who were nonverbal, unable to speak, for molestation because he knew that they would never be able to complain. Well, he got caught and he confessed completely to the police, but we didn't have you know, witnesses who were going to be able to discuss this directly from the victims. We had this confession, and when the police were interrogating this defendant, they asked him, how many children do you think that you molested over the course of your employment? And he responded, oh, I don't know. How many stars are there in the sky? And, you know, that was obviously the type of statement that was, you know, going to be used in a huge part of the people's case. And the prosecutor was going to tell the arraignment judge, in asking for a high bail, that the defendant had made this statement about his, you know, the vast number of victims he had molested. But she absolutely knew that as soon as she went outside, she would be asked about this confession. So we talked about it in advance. She made her plan that she would tell the arraignment court about the statement, but as soon as she went outside, she would not repeat it. She would say, I've said everything that I can say about this in court already. And the reporters and TV reporters and print reporters who had the good sense to get there on time and get into court and get their place, well, they got it. And the ones who were not on time and didn't get it, too bad. That's just, you know, you snooze, you lose. That, you know, you don't help people out by bending over backwards and potentially committing misconduct by repeating things out of court that are this dangerous. So that's something to always be thinking about. The rule also talks about test results, or the refusal to submit, or the identity or nature of physical evidence that you expect to be presented. Of course, your common sense tells you that that would be very damning if you were going to talk about actual physical evidence. If that's part of a public record and you can speak in general terms and you feel like you're safe in your particular case, then that's something that you can do, but just be mindful that the rule specifically cautions you against that. Also, any opinion as to the guilt or innocence of a defendant, I think that that is a no-brainer for prosecutors. For prosecutors, you're not going to tell a reporter, you know, well, I'm sure he's guilty. I mean, your opinion is not relevant at all. Now, I will say that you do see defense attorneys break this rule all the time. Defense attorneys are constantly getting out there and saying, my client is innocent. And do I think that that triggers the exception in this rule that allows you to come back around and say, nuh-uh, I think he's guilty? No, I mean, that's just what they're doing. They're saying their client is innocent. I don't think that that triggers, you know, such adverse publicity to the people's case that now we're entitled to go spill a bunch of details about it. We just don't opine on that. Any opinion as to the guilt? Prosecutor, do you think the client, do you think the defendant is guilty? You know, we've issued the case. We've issued the case based on our issuing burden, which is we believe we can prove the case beyond a reasonable doubt in a court of law. And we will have to wait until the correct time to present that evidence in court, and that's all I can say about that. That's what you say. And of course, you can't say anything about evidence that you either know or should know is going to be inadmissible, and that if it got out would create a substantial risk of prejudice. And I think that's always interesting, because if the defendant has given a long statement that's kind of confession or admission-ish, and if there's physical evidence that you're telling the court about that links the defendant to the crime, what if you haven't been able to go all the way through it? What if the Miranda warning was hinky and you're not going to be able to use that statement in your case in chief? Or what if there was a search and seizure violation and you're going to lose a piece of physical evidence? The last thing you want is to have discussed that publicly so that it's already out in the public eye, attributed to you, and it's not going to come in your case in chief. You just don't want to take the risk of that happening. And this is a little part of the rule that everybody ignores, but it's part of the rule, so I'm going to say it. You're not supposed to comment on a case unless you include the fact that the defendant has been charged with a crime, but that's merely an accusation, and he is presumed innocent until and unless proven guilty. You hear defense attorneys say that a lot, and that's fine. Does that apply to us? Do we have to always remind reporters that the defendant is presumed innocent until and unless proven guilty? I think it just sounds sort of like blah, blah, blah coming from us. You never see that included, or rarely see it included in TV news stories. You know, you don't. So I don't worry too much about making sure I include that in everything that I say. Now, there also, you know, the rule goes on to talk more about how you can respond to adverse prejudicial statements that have been given, but just be careful when you have decided that you're going to go to war with a defense attorney in front of the cameras, that you don't cross the line so that you've given out so much information in detail that you cause yourself problems with your case. Now, I'm getting to Janet's question about, well, what if your officers have said something that violates this rule? Can it be imputed to you? Well, you have ABA Model Rule 3.8, which says that basically prosecutors have a responsibility to exercise reasonable care to prevent investigators, law enforcement personnel or employees, or anybody else associated with the case from making an extrajudicial statement that the prosecutor would be prohibited from making. Now, the way I look at this is that when we are assigned to a high-profile case and we know a case is coming our way. Now, sometimes the police will be giving out details of a case before a suspect has been apprehended and, you know, or charged, when it's still completely in their jurisdiction, when the case has not come to us yet. I think there's a reasonable question: are we going to be considered responsible for something that they say before we've even received the case? I think that's a stretch, and I would not really seek to interfere with information that was being given out by police before we even have the case. Recognizing that defense attorneys will always, look for openings to come at us if they think it's something we ought to have prevented. But once the case is coming our way, once we have an arrest, once we have a defendant identified, at that point you could reasonably infer that this rule says you should reach out and tell the police they can no longer talk about facts X, Y, and Z, because you would be, as the prosecutor, prohibited from making that statement. And I know a lot of people don't like this. A lot of people feel like this is patently unfair to hold prosecutors responsible for something that a police officer says publicly that you didn't approve of, know of in advance, or think was a good idea. And some time ago, when this rule was created, a bunch of prosecutors in Illinois tried to have this part of it thrown out, that it was not appropriate for prosecutors to be held responsible, but it stands. It's not too vague, it's not overbroad. So just consider, if you have a really high-profile case that the police have been talking a lot about, that once they get close to an arrest or it comes to you, to say something, whether it's just a phone call that you've documented in your file, or write a letter saying, at this point, I'm going to ask you not to say anything that Rule 3.6 prohibits. So be cautious and mindful of that. Now, often you can be contacted by reporters. I'm going to talk about two things that are super sticky. When you are contacted about a case that is currently in progress, usually you can handle that if you stayed within the rules. But when you are asked about a case you've rejected, that is something that you have to be super careful about saying, because you are going to be asked about details that are almost certainly not part of a public record. Of course, the statement is going to be extrajudicial because nothing about it is going to be happening in court. So now you're squarely in this rule of extrajudicial statements with nothing in the public record, but you may be asked to give an explanation about a case. And what can you say about that at that point? Pretty much nothing. I'll come back to acquittals in a second, but I'll give you an example. There was a football player that was accused of a sexual offense, and on the scale of what types of case draw big media interest, football players and sex crimes is right up there at the top. So we knew, because of police statements, that reporters knew that this case had been submitted to us, and I had the case, and I knew, after he'd been arrested, that I was going to start getting calls. We had done the victim interview. I discussed it thoroughly with my supervisors. We made the decision to reject, and the reporters' calls started coming in. I knew I couldn't talk about it. I didn't want to entertain a lot of questions that were just going to be, just kind of pushing for more details. So I sat down at my desk and I wrote this statement that you see on the screen. We've thoroughly reviewed the facts and feel that the facts do not meet our standards required for issuance. And I made it, in really large type, bold, and I started to return calls. And I probably returned 6, 7, 8 calls, and I read it off my screen. And I was committed to the idea that I wasn't going to go outside of this statement. So, that's what I gave them, and that's what they used. That's what they put in the newspaper. And I look at that and I think, to myself, well, brilliant quote. No, it's just a fair statement of what our issuing standards were. And, so you give them this, and that's something that they can use, but you've not even come close to violating your duties under the law. Now, I do have another question. I'm going to get to the question in just a moment, but I want to say something about acquittals. Acquittals are extremely sensitive and extremely dangerous. And you know, you can't come back after a jury has acquitted the defendant and argue your case in front of the media on the courthouse steps. You just can't do it, because at that point, you know, you no longer, you know, the jury didn't find it. It's disrespectful to the jury. You've absolutely left your absolute immunity behind. Now you're out on the courthouse steps, and if you continue to insist that the defendant is guilty and here's why, you're going to get sued, and you will not be covered by absolute immunity. You'll be lucky to get qualified immunity at that point. You know, you're not going to have truth as a defense because the jury has found another way if you get sued for libel and slander. So you want to be really careful about that. What I recommend to people is that they, if they have an acquittal and they're going to be asked about it outside of court, to write down what you're going to say. And the most dignified response that you can give is, we respect the opinion of the jury and we accept, we respect and accept the findings by the jury, and that's all I can say on the subject. If you're, you know, insanely angry, you could say something like, we don't agree with the jury's findings, but we respect and accept their ultimate conclusion after reviewing all of the evidence. That is, you know, still fairly dignified. You know, you've said that you didn't agree with it, but you acknowledge that they disagreed with you in a way that's respectful. Now, I think what you don't want to do, well, let's see, let me come back to this. What you don't want to do is say something like what you see on your screen right now. Look, I have all kinds of respect for Steve Cooley, and I understand that to lose this case was absolutely dreadful. But this was the headline on the front page of the LA Times the day after Robert Blake was acquitted of killing his wife. He, the DA at the time, Cooley, was quoted as saying the jurors were stupid and that the evidence showed that the actor absolutely killed his wife. And, you know, I get being mad about an acquittal. I absolutely get being mad, and I get being mad in Los Angeles where celebrities, you know, seem to skate, you know, if they have any kind of star power. So again, I get the anger, but I think if you just wait a little while and think about what it is you want to say, you'll come back to something that's a little bit more respectful. But again, I get the anger. So I'm going to go to Dolly's question. What are tips in handling damage control if your law enforcement agency makes a statement that's prejudicial? She has a case where the suspect was at large. It says we had an arrest warrant out. The next day, the suspect was apprehended in another state. The sheriff provided a press release about the suspect's confession, which lands on the front page of the local paper in a small jurisdiction. Well, I can understand how this would happen. You have this case, the suspect flees, I'm picturing a manhunt, they're able to get him in another state, so you know, you're not involved. You as prosecutors, your office is not involved. So then the sheriff puts out a press release about their, you know, admittedly good work about tracking this guy to the next state and getting him. And just to show you that we really got him, here's his confession. And that's blasted all over the page in a small town where everybody knows that this guy confessed. At that time, you know, the barn door is open and it's gone. So all you can do, you know, fortunately you didn't do it, okay? You didn't do it. Is it imputed to you? Maybe, because you're the one in court now when the defense attorney brings their change of venue motion or something, which is really all they can do. And there's no question that once in a great while there will be so much publicity about a case that a defense attorney brings a viable motion for a change of venue, saying that the person can't get a fair trial, and attached to their change of venue motion, is a copy of the front page of the paper, and you guys are going to, you as the prosecutors are going to have the laboring oar at that time to persuade the court that the defendant still can get a fair trial in your jurisdiction, or you admit, if you think that they can't and a change of venue is appropriate, you might agree with them. I mean, again, I think that would be an extreme case, but you've given me, pretty extreme facts. The one thing that you don't want to do is fight tooth and nail against a change of venue and then have every potential juror that comes through voir dire saying, oh, I know he's guilty. I read it on the front page of the Daily Star. So, I mean, you have to perceive fairly and accurately what damage has been done by this news release, and then work with the court to try to find a solution, if there is one, hopefully short of a change of venue, just because that's so inconvenient for people, hopefully, but you never know. Tough problem, and I feel for you there. Now, I want to talk a little bit about how you can actually tell your story, because you are not obligated to do it exactly the way a certain reporter or any specific reporter wants to do. You have choices. Now, you can go ahead and you can tell your story in the hallway when they follow you out of court after a court hearing. They can follow you out onto the steps. You can talk to them then. You can say, I will get back to you in a news release. You can issue a written statement. You can make a public statement. Now, that's different than a news release or a written statement. I will show you why. If it's something that lends itself to putting it on your office website, or you could have a formal news conference. That's not a news release. You could have a formal news conference if your case warrants and it's appropriate. Or you could even go off the record background if it was that really unique kind of case where you couldn't say anything publicly, but on balance, after weighing all of the pros and cons, risks and benefits, you feel like the reporter should be educated a little bit, and I will tell you the difference between going off the record and going on background. So you always want to work with, not against the media, to the extent that you can. Take and keep control over the process as well as you can. Don't be passive. You are not playing defense in this. You can be not aggressive, but be assertive and control the setting about how you want to handle it, and give the process the time and effort it needs to do it well. And I mean that in every way, shape, and form. If you get stopped in the hallway and the lighting is bad, tell the reporter you'll give them an on-camera interview, but you want to move somewhere so where the lighting is more appropriate. You don't want to, be in the dark. You don't want to look like a deer caught in the headlights. Move it to where you're more comfortable, where you aren't going to be pushed, where you aren't going to be crowded. Don't let them ambush you and just start rolling. Stop it and say, I'll talk to you, but we're going to move over here where there's more room, and we can all, do this calmly and, as a collective. There's nothing wrong with taking control. Now, if you're going to give the principles, just remember the buck stops with you. When you're the DA on the case, you're not going to blame anybody else for anything that's happened. You've got to do the right thing, live with the fallout. You pre-plan, know your message, know what you're going to say. When you have a reporter who's new on the job, who hasn't been in court, don't assume a level of knowledge about the process or about, individual things. The reality is they don't know what's going on, and they need you to explain it to them. So, be cognizant of when a reporter is truly not understanding something, and be willing and able to explain it, really to improve the quality of their work. You never say no comment. there's something that you can't say, this is something that the rules of ethics prohibit me from saying outside of court. I'm sorry, I can't discuss it. You always want to be straight, tell the truth, don't ever, lie. That doesn't mean you can't be vague or broad about something, but don't ever say something that isn't true, but take charge and get your side out while you have this opportunity. Now, a news release is a formal way of telling the media about something that's going on, whether it's a new program your office has instituted or a high-profile case or something that's occurred. I'll give you an example of it. You can completely control the scope of information that's given out. Here's a picture of a news release that our office put out when there was new evidence that came out of a child homicide, an old child homicide, and there was new evidence that revealed reasonable doubt. Well, what we did was we put out a news release, and you can see there that we had our press liaison's phone name and phone number, and then to the right you had the actual DA's phone number if they wanted to call and do follow-up questions. But in this news release, we could place a quote from our elected DA, right up front and center, and if the media wanted to just run with that, they could. That was just absolutely fine. Now, that's a news release where you take follow-up information. That's going to lend itself far more, this type of case, to this type of communication. Now, you can do what's called a written statement. A written statement is a carefully crafted writing regarding one message. You would do this instead of holding a news conference or a news release inviting follow-up or holding a media availability. Now, you can address a media question in a high-profile case. You can set the record straight without follow-up questions, and you can just send this to an individual reporter, or you can do a mass blast of emails to news agencies if you want. And here's an example. We had a child molestation case that was tried 3 different times in San Diego. So we had 3 jurors who found the defendant guilty over and over and over, but the case kept coming back reversed for various reasons, and the defendant was a teacher, so this had gotten a great deal of press and great deal of attention. So it was appropriate when we made the decision to not retry the case, we had to put out something publicly. So we crafted one sentence, it's a statement, there is no follow-up questions invited or being taken. We crafted the statement so that it would stand alone and speak for itself, and that was the end of it. And I can also tell you, this is a little prosecution trick, if you will, based on just knowing what news cycles are. This went out, the reversal came back, we took our time making our decision that we weren't going to retry the case, and we made the decision to let the media know, and we very intentionally, put this out late on a Friday afternoon. And Friday afternoon in the news business is just like Friday afternoons probably everywhere else. People are not exactly poised, raring to go. And this was given, pretty small treatment in the newspaper the following morning, Saturday morning, which is, one of the lowest readership times there is. So if it's something that you need to put out there but you don't particularly want to invite a lot of attention or follow-up, you have choices. You can also do a public statement, and I'll give you an example of a public statement. That's a formal way of telling the media about certain aspects of a case. It can be outside the courtroom, it can be, personal interaction with a reporter, but the disadvantage is you are open to questions. Here is an example of a public statement regarding a case that was dismissed. And after the case was dismissed, we wanted to make a formal statement about why. It was complicated, it was very detailed, it was too much to do on camera. So This is an example of a public statement that was very carefully crafted with the details about the dismissal in the public, for the public that were given out. Now, yes, there can be follow-up questions, but the reality is if you do such a good job crafting this public statement, maybe that will reduce the number of follow-up questions that you actually get. So think about whether that is appropriate. And here's an op-ed piece about the same thing. If you have something that has gotten a great deal of press attention and gone horribly south the way this case did, you might consider both a public statement and an opinion piece for your local newspaper's editorial section. I wouldn't be doing that all the time, but there are cases where it's appropriate and the public wants an explanation from you, and you can write it and submit it to the paper, and they can, do what they want. You might put something on your website. Create a news release tab that takes reporters of the public to news releases regarding certain cases. You can create a newsroom about high-profile cases with information that's already been released. And that's kind of a user-friendly thing to do for media if that's something that you want to do. So consider that as a possibility. There's lots of things you can put on your website that answers people's questions that is not going to be violative of the rule. You can also have a formal news conference when you have something that's really big. You don't do this on little things. This is only something that is going to be really big and of great interest. So you stage a news conference. You decide, going in, who's going to be there, what's the message, what can you ethically discuss. You plan it out. Maybe this is something where you want to have various individuals from investigative agencies be there. You divide up talking points. This is very carefully planned and choreographed, and it's driven by the message, what it is that you're actually going to do. And if you make the decision to do that, you start on time, it's scripted, have your own camera crew, if you can, record to make sure that nothing is taken out of context. Make sure you have legitimate members of the media who are there. This is not something that just, any person can get into. Be prepared for questions, but know when to stop talking and end it. So news conferences are very appropriate for certain things that are extremely high profile. So I've just got a couple of minutes left. I do want to make a couple more points that I promised. I'm going to skip past this for a second. I'm going to come back. I told you about off the record. What does off the record mean? You have clear rules with the reporter, meaning what you say is not going to be printed or broadcast. You would only use this in the extraordinary setting where you have a reporter you trust completely. You would say early and often, this is off the record, right? And you would repeat that through the conversation. We're still off the record, right? If you have a reporter that doesn't understand a very complicated scenario, off-the-record education may be appropriate and ultimately very useful. You make sure the camera is off and pointed away from you. You make sure the little skinny reporter notebook that they use is put down. They're not writing anything. You make sure you get an affirmative response to your question. This is off the record. We're still off, right? And of course, you all know what the downside of this is that you're going to get burned, and they decide that what you say is so juicy, they're going to print it anyway, and they're just going to burn you. And, that's the kind of stuff that people can never recover from if it really goes bad. So if you have any doubt about doing this at all, don't do it. So what's the difference between off the record and on background? Background is when it's on the record. It's going to be printed and used, but it's not for personal attribution, meaning it's not going to be attributed to you by name. So you might want to go on background. If somebody calls you and says, is it true, they've already got a little nugget out there about some piece of information. Is it true that something, 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 and you make your own decision that it is appropriate to go on background. You can say, okay, I will explain this and I will tell you this, but you are not to use my name. If you get this confirmed by a second source, you can go ahead and run with it. And then what that looks like in the paper when they actually print it, it would say, according to a highly placed source in the district attorney's office, blah, 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 blah. And that would be you. But, as soon as you go down that road, you've got to be mindful of the risk, because the big boss sees, according to a highly placed source within the DA's office, who might that be? If somebody figures out that it was you, or, if they suspect somebody wrongly and unfairly, you wouldn't want that. Again, these are the types of situations that you really, really want to think long and hard about before you step out on that tree limb, because it is, if it breaks, you're going down hard and far, and it will not be pretty. So, you always want to be careful. And I will close with this story. I'm going to go back about when you talk to reporters at all. I started saying I don't think they try to trick you, and I don't think they try. But when we're dumb, they'll take advantage of it. And on a slow news day once in our office, a long time ago, a reporter just was talking to a DA and said, hey, what do you like in a juror? When you're picking a jury, what kind of qualities and characteristics of people are you looking for? And the DA thought he was just talking, just educating. This reporter is interested in how I pick a jury. I'll just tell him, I want homeowners, I want productive members of society, and he goes through his list and he says, the prosecutor says, the one thing I really don't want on my jury is fat people. Fat people lack the discipline and the ability to focus and, the self-regulation that's needed to be on a jury. So I don't let fat people stay on my juries. And, he thinks he's done with the conversation, that it was personal in between him and the reporter, although he never said anything about it. And what's on the headline the next day? Fat jurors need not apply. You are not going to get picked for a jury if you're fat. And, it was devastating personally to the prosecutor, and he never saw it coming. Should he have? I think so. I think he was being a little loose with what he was talking about, knowing he was talking to a reporter, but just assuming it wasn't going anywhere. So these things can really be hard, but if you think and prepare and get your mind about what you're going to do in advance, rehearse, and if you're careful, nothing like that need happen to you. So I have that it's a couple minutes after 1. I've gone, I think, 3 minutes over, so sorry about that. Thank you so much for listening. And again, I'm Kate Flaherty with the San Diego County District Attorney's Office. If you are interested in following up with me in any questions, feel free to contact me at the San Diego County District Attorney's Office, and I'm always available. I have a bunch of great video examples of just these types of things. I'm always available to come to your state and do an ethics training on dealing with the media. So thank you so much for paying attention today, and good luck with your future conversations with reporters.
Thank you, Kate, for the excellent presentation. The APA webinar materials are available at no cost on our membership website, and we will be notifying you via email when these materials become available and how you can access them through a temporary membership. However, if you are a current APA member, you will have automatic access to webinar materials once they are available online. If you have any questions or concerns, please email us at webinars@apainc.org. Thank you for attending, and please do not forget to fill out the survey evaluation to be entered in the drawing for a free 1-year APA membership. Please visit apainc.org for more information and join us for the next Final Fridays webinar on March 29, 2013.
The organizer has ended the session, and this call will